good afternoon, everybody. You're in first appearance magistrate court. My name is Judge Kim Teresa Malika. Today you're going to be advised of what the charges are, and we're going to determine if there's probable cause. Please keep in mind, today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney. There's a public defender. I believe it's Mr. Romero. Am I correct, Mr. Reed?
Yes,
At the main jail. And we have Mr. Reed over to my right, who's from the public defender's office in the main courtroom. If you have a private attorney, please let me know when you step up to the podium. State, can you announce your appearance for the record, please?
Sarah Rivera on behalf of the state.
Thank you. All right, so we're not ready on Adams yet. How about we have a detective here on Trevor Lorenzo Paquette. You ready on that?
Yeah.
Yes.
Okay. State, do you have more than the warrant to arrest? I didn't get it.
You didn't? I didn't give it to you?
No. Unless it's here, I don't see it. Hold on, no.
I thought I gave it to you, no?
All right, so what we're gonna do is, I wanna take a moment and just read this. So let's just go, I just got it, so let's go off the record and I'll be right back, okay? on Trevor Lorenzo Paquette.
I don't have. Oh, shimmy. What the hell? This is a different person.
Okay, state, announce your appearance for the record and then defense.
Not even it. Sarah Rivera on behalf of the state.
Brian Reedy on behalf of the defense.
Okay, all right, Mr. Paquette, you are charged with 1 count, fraud, use, possess ID of another without consent, $1,000 bond. Count 2 is kidnap a minor for ransom, reward, shield, or hostage, no bond. Counts 3, 4, 5, and 6 are sexual assault with a weapon, sexual battery, a victim over 12 years of age. Court does find probable cause. You do have a question state for the detective here with the alleged victim's initials. They have TDL and TW. Are those 2 different victims?
Who? 2 different victims.
I think Thomas David Lopez fraud.
Is in this case, Your Honor.
Okay,
The case we have right now.
okay. All right, and the alleged victim in counts 2 through 6 is TW?
Yes, ma'am.
Okay, thank you. All right, state.
Your Honor, I would be asking that we leave the bond set in place currently as no bond and wait till he gets to his division judge.
All right, so you're asking for a finding of proof evident presumption great?
I am, Your Honor.
All right, detective, you can step up since you're here. Just state your first and last name, spell your last name for the record.
Deborah, last name Levy, Levy.
Okay. All right, defense?
Is the detective going to be testifying to anything, Judge?
No, I just wanted to note that she was here. I don't believe so.
I'm sorry?
I don't believe so. I just wanted to
Okay.
note that she was here.
All right, because I know she might have more information than what's contained in this affidavit, but based on the affidavit alone, I would state that proof evident presumption great is not present in this affidavit. This is an incident that allegedly occurred in the end of December of 2003, December 28th and December 29th of 2003, which is quite some time ago. Aside from the statutory arguments that I guess will probably be made at a separate time, as far as the actual facts of the case are concerned, the only evidence connecting Mr. Paquette to this incident is a photographic lineup that was shown to the alleged victim, I guess approximately 15 years after the incident took place. Maybe the detective can enlighten us as to what photograph was used, how old that photograph was, whether it depicted Mr. Paquette as he appeared back in 2003 or how he appears today. There's no DNA evidence linking Mr. Paquette to this offense, despite the fact that there is evidently DNA based on the alleged victim's recitation of how this act was committed or how these acts were committed. There would be DNA. Whether they didn't bother testing that, or they haven't tested it yet, or there's something further forthcoming, or it's insufficient, I don't know. What I do know is that there's nothing in this affidavit to indicate that there is any kind of positive DNA test connecting Mr. Paquette to this incident when one would expect there to be so. So then, based on that, the only thing we're left with is a photographic lineup, which, you know, photographic lineups can be very, very subjective. And we don't have a videotape of the alleged victim going through that photographic lineup process, I'm quite certain. We don't have I don't know if we have the photographic lineup here for the court to take a look at. But based on the fact that that's the only evidence connecting Mr. Paquette to this offense, Judge, I would say that this affidavit falls short of proof evident presumption great, which is the highest standard that we have in our criminal justice system. So I would ask the court not to find proof evident presumption great and set a bond for Mr. Paquette. I believe he's entitled to one under these circumstances.
Yes, Your Honor. Additionally, he's out on bond on case number 179836 CF10A, which is the same charges that he's facing today.
Well, that cannot be a violation. This new allegation, which is actually, I guess, an old allegation, cannot be the basis of affecting his bond on that other case.
Okay. All right. Mr. Paquette, I have reviewed the affidavits filed in your case and other documents, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. And this is on counts 2, 3, 4, 5, and 6. We can address 1 in a moment. So I find probable cause. I further find the proof of guilt to be evident or the presumption great. And that's in counts 2, 3, 4, 5, and 6. Therefore, sir, on counts 2, 3, 4, 5, and 6, you are going to be held without bond until further order of the court. This order is without prejudice, sir, for you to file a motion to set bond. Hold on. Sir, you have the right. Sir, you have the right to remain silent. Anything you say or do can be used against you. Okay.
But with the state just mentioning that the charges that I'm out of bond on is the same charges that I'm being similar for each one, that made it seem like, okay, this is some kind of predator profile. So of course you're not going to want to put a bond or set a bond. You're going to find it evident great, which the councilman just said it's not great because they only have a photographic lineup. One, he had made pretty good points here. You know, your tape showing the and I don't know anything about DNA. I spoke to the detective yesterday. Okay, y'all gonna let the detective say what they have to say about this case? This 15-year-old case? Because I was out on bond with a $90 to $96 paying job per day for Brooklyn. You know what I'm saying? Trying to put the pieces of my life back together. Bam, here comes a 15-year-old case. This ain't really right. Really ain't right. But you, right now, Miss Talisa, I can't really pronounce her last name here, is the person who's going to make the decision on if I'm going to be locked up, go back to prison, or if I'm going to be able to go out and work until these cases get resolved.
Okay, well, today.
If you give me a no bond, I'm going to lose a job that pays $90 a day. Ain't too much people in here having a job that pays $90 a day. You understand what I'm saying? With my education, it's hard to get a job that pays $90 a day. And I've been blessed with it. But now because of a 15-year-old case and the cases that I'm fighting my freedom for right now, the cases that I was out on bond on, you're gonna be so adamant to go ahead and just throw that away. So I'm actually asking the judge to go ahead and consider a great probable cause, a great proof for this probable cause. Because I know when I spoke to the 2 detectives yesterday, I spoke my side of the story. I'm pretty sure, like she said, it's my story, her story, and somewhere in between is the truth. So I'm pretty sure that I can get to the detective as best possible and find out if that truth is still there. Because I don't think there's no way that I should be held on no bond for something that happened 15 years ago with the circumstances of that case. I'll go ahead and give you some time, man, but it's actually not fair. And I can't believe I was, if I didn't open my mouth, it was just going to go ahead and that easy. But I'm going to open my mouth. It's my life I'm fighting.
Okay, are you finished, sir?
Yes, ma'am.
All right. Today is not your trial day.
I understand that. I'm
So,
not looking for a trial.
okay, I'm just letting you know. Today is only, sir, to determine if there's probable cause, which probable cause has already been found. It's just a determination of proof, evident, presumption, great. So you are going to be held without bond until further order of the court, 2 through 6. It's without prejudice for you to file a motion to set bond through your attorney with your assigned division judge and request a hearing under State v. Parker. On count 1, does anybody want to be heard with regard to bond of $1,000?
No, Your Honor.
Okay. State defense?
No, Judge, I think Mr. Paquette would be best served going in front of his division judge on a motion to set bond. I think that's the next logical step for him.
Okay. All right. So $999 on count 1. Sir, you're not to have any victim contact, direct or indirect, with the alleged victims in the case with the initials TDL and TW. Direct or indirect, sir, means no contact in person, texting.
We can hear you.
Said T as in Tango, D as in Delta, L as in Lima. And T as in tango, W as in whiskey. There's two different alleged victims in the case. One's for the fraud, the use or possess an ID of another without their consent. All right, sir, well, you can talk to the public defender, or if you get an attorney, about the names in the probable cause affidavits or in the warrants to arrest. You can get their full name. You are not to have any contact, direct or indirect. That means no contact in person, no calling, texting, anything through social media, no writing, and no contact through third parties. Do you understand, sir? I'll take the non-response as a positive. As an affirmative response is yes. Thank you.
Thank you, Your Honor.
Thank you. Okay, Paris Mashante Webster. Okay.
Oh, again, Your Honor.
Hi, how are you?
I'm doing well.
Okay, we're back.
We are back. And I received the ad charges and,
I don't have them here. Let me see if I have another.
I put them on your,
I didn't get anything. The only thing that,
We have two over
excuse me,
here.
that was on here was the two calendars for.
You can call these.
I'll give you another one.
Yeah. You have a copy, Mr. Reedy?
I don't need one, Judge,
Okay,
and I don't have one.
okay. Oh, that's right. Sorry, Mr. Hubbard.
it's okay.
Okay, so, ma'am, Miss Webster, you have burglary of an unoccupied conveyance. There's no bond on that currently. We have to talk about bond, criminal mischief, over $1,000, $500 bond, and then we have petty theft, second degree, first offense, $25 bond. And then we have the aggravated battery with a deadly weapon. So there's 4 charges. I thought there were 3 total. 4?
Yes.
Okay, thank you. And so that, we need to talk about bond as well. So, state,
Your Honor, I would just be seeking $1,000 bond on count 2, and let me look up the other one.
we need to write these on a separate sheet, Madam Clerk, or would you like me to write them on, I can continue them on here. Is that okay? Okay, I'll do that then. All right, go ahead, 1,000 on 2, and leave the $525 in place?
Yes, Your Honor, and I don't believe we addressed count 1 this morning either.
No, we did not. So what would you like on count 1? What is the state's request?
I would be asking for a $7,500 bond on count 1.
Okay, 7,500 on 1, 1,000 on 2. Okay, all right. Any objection to probable cause?
No,
Okay.
but,
Court does find probable cause. Go ahead, sir, I'm sorry.
well, Your Honor, their family is, they were here this morning, they're back again. I spoke to them about their financial circumstances. You know, earlier we had, I believe it was a $1,500 bond, or $2,000, on the mother of Paris, so that's $200. Their financial means are between $500 and $1,000. They're in talks with a bondsman. So as far as the 7,500, I do realize that it's a pretty serious offense, serious allegations. There's more to it than what's contained within the 4 corners of the probable cause affidavit, which I will not get into today. But you know, considering that Ms. Webster, I believe she has no criminal history. Is that correct, State?
That's correct.
Okay, so given that, her substantial ties to the community, her support, financial support being anywhere between $500 and $1,000, I'd ask Your Honor to please reconsider the $7,500 to a lower amount so that they can post bond and we can work this case up for trial.
Okay, so the court does find probable cause for counts 1, 2, 3, and 4. Court is going to order no victim contact, direct or indirect, with the alleged victim in the case with the initials ND. Do you understand, ma'am? Yes. All right, and I don't know if you heard me telling the other gentleman, direct or indirect means no contact in person, calling, texting, writing, nothing on social media, even liking, disliking something, commenting to it, and nothing through third parties, okay? Court is gonna do, just trying to see their address. So you live at 8833 South Isles, what is it, Court? Circle, Tamarack, Florida.
She has a residence in Miami too, right?
It has the wrong address on here, by the way.
Just to let Your Honor know, and maybe Ms. Webster can clarify, she does have another residence in Miami. Is that true, Ms. Webster?
Yes, currently I am still living in Miami. I was moving to Broward at my mother's house this weekend.
Okay, so you're no longer going to be residing in the Miami address?
It's still, not until the 8th. I mean, the 8th is when I would be officially not living there anymore.
Okay, so never mind.
All right, so it's South Isle Circle.
Yes.
Okay, because it has CIT on here, so I just want to make sure. And that's Tamarack?
Yes.
All right. All right, so this is what the court's going to do. On count one, court's going to set bond at $2,000. Count two, the court's going to set bond at $500. Count three, the court's going to set bond at $100, and count four, the court's going to set bond at $100. It's a total of $2,700. However, the court is going to do, I want her to maintain at least 1,000 feet from the alleged victim's residence, work, and school.
Okay.
I don't know if she goes to school, but I just always say that.
She does.
I am going to put her on a GPS open schedule. Court has a concern because she said it's alleged that she used a box cutter.
Okay.
Okay, so that's 2,500, 100, 100, so 2,700 total. And that's it, okay?
So level 2, open schedule.
Open schedule.
Gotcha. Thank you so much, Your Honor.
Thank you. Good luck.
Thank you.
No, just open schedule. It's just, Mr. Hogo, it's just an open schedule. They don't call it. the-
Right. It's not, they're not limited
Same thing,
to,
but she doesn't have to, it's an open schedule.
okay, thank you.
Okay.
Thank you.
Thank you. Good luck to you.
Oh, one thing, Your Honor, as far as travel, she does go to college in Miami, so
That's fine.
I
I
hope
have
that's
no
not
problem
an issue
No,
with
not
pretrial.
at all.
Okay,
Okay?
thank you.
Thank you. All right, Sean Daniel Simeline?
This is, wow. What happened?
Hello.
Up in the back.
Good. Which case are you here on?
I'm here on, but I don't know if they found it yet.
What is it?
His last name spelled Lucien. First name is Kenneth.
Is it, what page is it on the docket?
It's not on the docket.
Okay, it's gotta be this afternoon
Yeah,
then.
it's
It's
supposed
gotta
to
be,
It's not on this afternoon's docket.
It's supposed to be.
It's not on the docket. I'm looking at it.
all right, let's pull up, can you give us the spelling of a name? My judicial
Sure.
assistant, I'll look it up.
Sure. Last name is spelled Lucien. First name is Kenneth.
When was he arrested?
Last night, 11 o'clock. It wasn't domestic violence. It was 4 charges. It was petty theft, 2 grand thefts, and a robbery snatched without.
I have Sean Daniel Similgen. Looks like Simil or Jen? Okay,
Similar, same charges, right? Might be the same.
I think so. Is that a co-defendant?
I'm assuming.
Matter of fact, there is no paperwork attached to this. What's happening? Is this a co-defendant?
It may be. When I look at the charge, I see it's so similar. I believe it might be a
He is a co-defendant.
He is a co-defendant?
co-defendant.
Lucien, you're saying?
Yes.
LU? He's a co-defendant. We have Similin, the one that you called
So
up.
how could you
And
be arrested
Adams.
last night at 11 and not being, where's the police, where's the
How old
probable
is he?
cause
Is he a
affidavit?
juvenile?
She's checking right now for you.
On, Judge, I show
18.
no
He
paperwork.
just turned
on him
18.
on the docket.
Yeah, he just turned 18.
All right, have a seat. We'll
Okay.
have to come back to it, okay?
Thank you.
The office will call me back, Your Honor.
That's fine, no problem. All right,
Simoleon
Henry
over there?
Adams, are we ready on that yet, or are we still waiting for the mother?
Okay.
All right, come on up. Let's call Kendry Levon Adams, please. Is this a co-defendant or no? Just happened to be one of the same charges.
I don't think we have any of the co-defendants on the docket. I think Mr. Adams is the only one.
Here it is, Kenneth Lucine, Sean Simoline, and Wilvins Blue-Urzard.
This is a co-defendant?
Blue-Urzard.
What's his last name? Adams.
All right, what I'm gonna do, sir, is
Anything? I don't think she does.
give me one moment, ma'am, okay?
I'm not sure.
Hey, we're gonna recall this case. I'm gonna have Michelle make copies because we're missing paperwork for the co-defendants, okay? No, everything. But leave my tabs on the,
Right?
Yeah.
okay, yes. Next one is Anna Marie Santiago. Sorry, ma'am, we're trying to get the paperwork, okay? What, Mr.?
She's here, me?
Okay, all right, Miss Santiago, good afternoon. You have grand theft auto, $1,000 bond. Count 2, possession of cocaine, $1,000 bond. Count 3, possession of cannabis, 20 grams or less, $100 bond. Count 4, possession of drug paraphernalia, $100 bond. And count 5 is grand theft between $300 and $5,000, $1,000 bond. Total bond is $3,200. The court does find probable cause, unless I hear an objection. Defense?
Judge, I would argue that the amount of cocaine in count 2 is a residue amount,
Okay.
if I'm reading this correctly. And ultimately, if that is correct, it would probably be filed as a possession of drug paraphernalia,
Okay.
a misdemeanor. I'd ask the court to take that into account when setting bond.
Okay. So it's a residue case, probably. Okay. Habeas custody. All right, ma'am, this is what the court's gonna do. The court's gonna order no victim contact, direct or indirect, with the alleged victim in the case with the initials SS. Did you hear me tell someone else what direct or indirect means, ma'am?
I don't think she heard you, Judge.
Okay, that's fine. All right, you're not to have any victim contact, direct or indirect, with the alleged victim with the initials SS. That means no contact in person, calling, texting, writing, anything on social media, and no contact through third parties. You're also not to return to the Walmart Supercenter at 4301 South University Drive, Davie, Florida. If you return there during the pendency of this case, while there's a no return order in place, you will be arrested. Do you understand?
Okay.
All right?
Yes.
All right. State, anything further?
No, Your Honor.
Defense?
Yes, Judge, it's being Miss Santiago. Unfortunately, at this time, she's financially indigent. She is homeless. She's 32 years old, but she did advise me this is her first arrest ever.
If the state can verify that, Judge, considering my colleague's argument, for mitigation purposes, these are all non-violent offenses, I would ask you to consider releasing the Santiago ROR.
She has 2739 South US Highway 1, Fort Pierce. Is that an address where she gets her mail?
That's an old address, Judge.
Do you have an address, ma'am? Not where you live, where you can get mail or notice?
I don't have that.
Okay, so where are you living, on the streets?
Yes.
Was working, I believe, before at Wendy's, but unfortunately, that was about a month ago when she lost her job, Judge.
Okay, defense? For prior record?
State, you mean, state, you mean.
Pardon?
You said defense, state, you mean.
I meant state.
Yes.
Your Honor, the only other prior that she has is the one that's count 5.
Pardon?
The only other prior that she has is count 5, the one where she has a capias on.
I see.
Not excessive cases.
Yeah. All right, so the court's gonna put her on pretrial release, but this is my concern, ma'am. How are you gonna know about your court date?
Let me explain it to her and see, give her some useful advice, Judge. Go ahead and look online for the clerk of courts. She said she can do that. She knows how to use a computer, and she'll be doing that to keep up with the court.
Okay. And if she does get a mailing address, she can change it through the clerk of court. She can either come here, but she has to do it in writing and put her case number. Okay?
Yes, sir.
All right. All right, thank you, ma'am. ROR on all counts, pretrial release standard. You have to, did you tell her, Mr. Romero, she has to report by, I was gonna say Monday, it's the week past the weekend. So by tomorrow, yeah.
I haven't told her, but I'm gonna tell her right now.
Okay, thank you.
Thank you, Judge.
Keith Levon Floyd, please. Keith Levon Floyd.
Stole it.
Oh, no.
Yeah.
Anybody know where he is? Is there a Mr. Floyd there? Did he bond?
He bonded.
All right, Mr. Floyd bonded. Then we have Diego. I will let Mr. Romero say that last name.
Diego. There you go.
Can you say that?
Can you say it again, sir? Elizondo Arias.
Okay, thank you very much. Sir, you have trespass, failure to leave property upon order by owner. Bond is set at $25. Okay, sir, you're not to return to the Spring Tree Country Club Plaza. Do you understand? I don't even want you in the parking lot. You understand? That includes a parking lot, Mr. Romero, okay?
I can't go back to the parking lot either, okay?
All right, so what are we doing with this $25 bond?
Judge, at this, in speaking with Mr. Arias Lando, he's not gonna be wanting to resolve it. He's gonna go ahead and self-bond.
Okay. Does he need an order?
Yes, to access to his property.
All right, thank you. Mr. Reedy will do it. Court does find probable cause, no return. Thank you. Ivan Aristatis, pause, please.
Bonded, Judge?
Thank you. Armand Hugh David.
He's approaching, Judge. I think he's trying to search the public defender.
Okay, all right, Mr. David, you have a DUI, alcohol or drugs. First offenser, $500 bond. Count 2 is a DUI, unlawful blood alcohol level above a .15, or accompanied by a person under 18 years of age or under 18 years of age court does find probable cause. Can you make the bond, sir?
Under 18 years of age? I don't understand.
It's, you either blew over a .15, or you had a child 18 years of age or younger. Okay, well then, hold on one second, let me just.
He did.
You did.
Yeah. Your Honor, it's the enhanced aspect is the breath alcohol
I don't see
content.
the breath here, I'm looking,
It's-
.26.
Yes,
okay.
Your Honor, it's on the second to last page.
Yes. All right, sir, so you blew over a .15. So bond is set at $1,500. Can you make that bond? Is there anybody that can bond you out?
I have my credit cards upstairs, but the officers told me that I can't take out more than $1,000 on them. I have access to the money right now, but
All right, has he ever been arrested before, State?
Yes, Your Honor, in 2011, he was arrested for DUI that was amended to a reckless driving.
I took the back on track.
Okay, hold on, sir. Don't talk about the facts of your case. Just let's talk about bond, okay? Today is not your trial day. All we're doing is determining what the bond is. Do you live at 1254 Southwest 26th Ave, Deerfield Beach, Florida?
Yes,
33442?
yes.
All right. Is there anybody that can be called? Have you been
Somebody
able to make
else,
phone
okay.
calls? No? Do you know their number? So there's no one to call. It's not that you tried to make a phone call and you weren't allowed, you just don't have anybody you can call for bond.
I have my own personal money.
Okay, this is what the court's gonna do. Court's gonna ROR him and put him on standard pretrial release. No alcohol or intoxicants, sir, except prescription medications are allowed. So, can I get a deputy to give Mr. David a map to pretrial, or Mr. Romero? All right, you have to report there, so ROR on 1 and 2, standard pretrial, which means you have to report within, sir, listen to me, it's important, okay? Pretrial services is around the block from the courthouse, that's the map. They close at 4 o'clock, but you can only show up there till 3.
Do I need to bring the $1,500 to bond?
No, I'm RORing you. That means that I'm not requiring a bond, but you have to be in pretrial services. Pretrial services means, sir, that you have to report within 24 hours, so you're not gonna get out before 3 o'clock today. So what's gonna happen is you have to report by 12 o'clock tomorrow or within 24 hours of being released to that address that's in your hand. They will explain to you, you have to just call in twice a week and you have to report once a month in person. No alcohol or intoxicants except prescriptions. If you don't report within 24 hours of your release, a warrant will be issued for your arrest. So make sure you report to them tomorrow. Okay? All right, thank you, sir. Good luck to you. You should get a court date, sir. You're gonna get a court date. Sir, you're gonna get a court date within the next 7 to 10 days, maybe 14 days. You can go to browardclerk.org. If you do not get a court date, make sure you show up, okay? Thank you. Zebedee Jerome Watkins.
Medical reset.
Raymond Mitchell Lipsky.
Declined our invitation to attend court.
Okay, Mr. Lipsky.
North Broward, Judge, but he refused to
All right,
come.
Is there a Raymond Mitchell Lipsky at North Broward?
He said he's.
Okay, Mr. Lipsky.
Your Honor, he refused.
Okay, and Mr. Lipsky refused and voluntarily absented himself from court today. So the court is gonna find probable cause for possession of burglary tools, $1,000 bond. We need to talk about bond state on burglary unoccupied dwelling unarmed. Possession of cocaine, $1,000 bond, and drug paraphernalia and or used, $100 bond. State, what are you asking for on 2?
Your Honor, I'd be asking for an additional $1,000 bond on count number 2.
So 1,000 on 2?
Yes, Your Honor, and just so you know, he does have a case pending, a felony for possession of methamphetamine.
Okay. Mr. Reedy, is your office gonna be representing him? Sure, no problem. Okay, sir, we're gonna give you a copy.
It does not appear as though we represent Mr., oh, wait a second, hold on, let me check one other thing, Judge.
What's his bond on the other case?
He actually has a KPS on that case for $1,000.
All right, so court's gonna set $1,000 bond on 1, $1,000 bond on 2, $1,000 bond on 3, and $100 on 4. Or you know what, on 4, I'll ROR him.
Does not appear as though we represent Mr. Lipsky
All right, thank you.
on his pending felony.
All right, you might wanna send someone over, maybe?
Yeah, we'll see. I don't know if he's got private counsel or what. I'll look into it and find out, Judge.
All right, thank
I'm
you.
showing that you do represent him.
Really?
On the
What's the
felony.
case number?
1515650 CF10A.
The last thing I see on this is December of last year. That he was out of custody and, let me see. Well, I guess now that he's back in custody, I guess maybe we will. All right, well, anyway, Judge, we'll look into it.
Okay. All right, Mario Lorenzo, please. Come on up, sir. How you doing, sir? All right, well, I'm glad you're getting medical attention for it. Count 1, sir, you're charged with robbery with a firearm. No bond attached to that. And count 2 is resisting an officer without violence. Court does find probable cause. Court is going to order no victim contact, sir, direct or indirect, with the alleged victim in this case with the initials MEL. And that means no calling, texting, in person, writing, anything on social media, and no contact through third parties. Does anybody wish to be heard with regard to bond?
Yes, Your Honor, in this case, it is a punishable by life offense, and I would be asking that Your Honor find proof evident or presumption great and hold him no bond. He does have prior thefts, most recently.
Well, I would object, Judge. That has nothing to do with whether proof is evident or presumption is great. That has to go to bond.
All right, so why don't we just respond to proof evident presumption great on count 1?
I would, Judge. We would object to the court making a finding of proof evident presumption great on this case. That is the highest standard that we have under our criminal justice system. What the state has produced to achieve their goal of having Mr. Lorenzo held without bond is to provide the court with a probable cause affidavit and nothing further. I would point out that no firearm was recovered and that the identification process in which the alleged victim supposedly identified Mr. Lorenzo as the gentleman who robbed her was done as a show-up, which is an inherently suggestive and unreliable method of making an identification. Mr. Lorenzo made no statements to the police of an incriminating nature. I don't believe there was any evidence connected to the robbery found either in Mr. Lorenzo's possession or in the vehicle, if I'm reading this correctly. And that is not proof evident presumption great. Probable cause, I would agree, as a very low standard of probable cause. That has been met, but certainly not proof evident presumption great. So I would ask the court to set a bond for Mr. Lorenzo.
Your Honor, I believe the facts of this case, he had a gun. He additionally hit her with a gun, which is not on here. The state's not charging yet, but he hit her with the weapon. They did see redness on the side of her face. She did identify him. I mean, I think that this is definitely something that's warranted to be held no bond. It's extremely dangerous.
Says the victim did state to me that, meaning the officer, that the suspect had removed his shirt, but she recognized his face. So I've reviewed the affidavit filed in your case, sir, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, you're going to be held without bond on count 1 till further order of the court. This order is without prejudice. For the defendant to file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. So proof evident presumption great is found on count 1, no bond. Anybody want to be heard? On count 2, actually, it's an ROR. There's no bond attached to it. So, sir, you're to have no victim contact, direct or indirect, with the alleged victim with the initials MEL. Do you understand?
Yes, sir.
All right. Thank you very much. Good luck to you.
I would ask you to sign an order allowing me to photograph the children residents and use that as a stain.
Sure, no problem.
Scrattish.
Granted.
Oh, yeah.
Donovan Jean Scrattish.
Let me look up. Did he have? Is it? Yeah.
Donovan Jean Scrattish.
This one's, oh, whatever. This one's really bad. Is it?
All right, let's hold on a second. All right, I'll take his case. I wanted to talk about, right after this, about the 3 co-defendants. Where are their names? Okay, Mr. Scrattish. Give me the 3. Yep. Mr. Scrattish, you are charged with robbery with a firearm. Sorry, robbery with a weapon. Thank you, Mr. Reedy. Court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials PGS. Do you understand, sir?
Do you understand? Yes.
Okay. All right. No victim contact, direct or indirect, sir, means no contact in person, calling, texting, writing, anything through third parties, okay? Let's talk about bond. State?
Your Honor, this is another case that is a punishable by life offense. I would be asking that Your Honor find that proof evident or presumption is great and hold him no bond. The facts in this case, he actually ended up cutting the victim with the knife that he used while stealing the bicycle.
I show this as robbery with a weapon, Judge. I believe Mr. Scrattish is entitled to bond. I don't think it's listed as a deadly weapon. It's robbery with a weapon.
And Your Honor, it's robbery with a firearm or deadly weapon. So in this case, it would be the deadly weapon aspect. He was using a knife.
Yeah, but it's not listed that way.
It says it robbery with a weapon, 1M.
Right, and that's
And
a
F1.
knife. Mhm.
and presumption, grade type of offense.
I'm just looking at the statute that's charged. It's 812.132B.
Okay, give it to me, 812.
812.13, subsection 2, subsection B. If in the course of committing the robbery, the offender carried a weapon, then the robbery is a felony of the first degree.
This is a first-degree felony punishable by life. And the difference between A and B is just that A is with a firearm and B is with another weapon.
A states, if in the course of committing the robbery, the offender carried a firearm or other deadly weapon, then the robbery is a felony of the first degree, punishable by imprisonment for a term of years not exceeding life. That's A, robbery with a firearm or a deadly weapon. That's not the statute that Mr. Scrattish is here on. Mr. Scrattish is here on 812.13.2b, which says if in the course of committing the robbery the offender carried a weapon, then the robbery is a felony of the first degree, which would be a 30-year felony, not a life felony. I'm just talking about what Mr. Scrattish is charged with. If the state wants to file something different down the road, that's a different story. That's a separate issue. But according to the probable cause affidavit, the statute written on here by Officer Bojanowski is 812.13.2b, which is clearly a first-degree felony, not a first-degree felony punishable by life. The docket also reflects that. Mr. Scrattish, according to the docket, is charged with robbery with a weapon, not robbery with a deadly weapon.
Okay, so State, what would you like to do? You want to pass it and
Judge, then at least based on his priors, he has prior violations of probation, that you wouldn't, at least a $50,000 bond in this case. He additionally did cut the victim.
I don't have any further legal argument. Mr. Scrattish is entitled to bond. I mean, that's my position.
okay, so let's talk
And the
about
state
bond.
seems to be in agreement.
State's asking for 50,000.
And through Mr. Scrattish, unfortunately, the $50,000 bond which the state is suggesting is something unattainable on Mr. Scrattish's behalf. Right now, unfortunately, he's unemployed. He's currently looking for employment. He's been here 40 years in South Florida. He lives in Plantation. He works in the fishes. He's been living here for about 1 year. There's nobody that he can, he's going to plan on contacting his girlfriend. He's going to be asking Your Honor to sign a phone order allowing him to have access to his number so he can contact his girlfriend. He believes the most that maybe she can come up with is $1,000. So it's less than $1,000 bond.
Okay, sir, no victim contact, direct or indirect, with the alleged victim with the initials PGS. That means no contact in person, calling, texting, writing, social media, or through third parties. No possession of any firearms, ammunition, or weapons, and you surrender any, if you do have any, to your local police department immediately upon your release. The court is going to set bond in the amount of $50,000. Thank you. All right, so I'd like to figure out why we can't have a magistrate hearing for Mr. Adams, Mr. Simmelgen, and I think it's somebody else? Kenneth. Who do we have here out of those three?
Judge, the first person you have here, Mr. Wilden Forza.
Okay. Is there a Sean Simmeline?
Sean Simlin? No, Judge.
How about Kenneth Lucian?
Your Honor, we were notified he'll be on the docket tomorrow morning. We didn't receive his
Okay, but we have the paperwork, it's the same one.
Mr. Kenneth,
I think it's,
I have Similian, Sean, but we don't have the paperwork for Mr. Kenneth Lucian.
hey, who are you here on?
I'm here for Kenneth. Lucien. He's a co-defendant.
I mean, he was arrested last night, he should be magistrated today, so.
Yeah.
Let's, can we get some paperwork for him? We have, is that paperwork state you wanna look at it? Seems to me to be sufficient to argue this hearing.
I believe so, Your Honor, because it does have all of their names on all of the probable
Yeah,
cause
so it's gonna
affidavits.
be the same charge. Unless you wanna reset them for tomorrow, I don't know, in the morning.
Should we reset them?
She's gonna get the paperwork.
Oh, right now.
Kendry Adams, come on up. Do we have a Kendry Adams?
Do, Judge. He also has family here. His mother and aunt are present.
Yes, come on up. All right. All right, so I need paperwork for Kendry Adams. Oh, I have it for Kendry Adams. Kenneth, I'm sorry, Lucian. I do not, that's the other gentleman, right?
Yes.
How about Flu Rizzard?
He's here present, Judge.
Okay, so we have Flu Rizzard. We need Sean Simmeline.
Oh, he's
Do
not.
we have him?
No, he's not here, Judge.
Judge, I show no paperwork on my docket for him.
We have paperwork, right? We have Simone.
Yeah.
It's the paperwork that, did Michelle give it to you?
I have Mr. Florizard and I have Mr. Adams.
So you want to magistrate them today, or are you going to be representing them, or? Because I
well,
am going to represent, I am going to do Mr. Adams.
Oh, he's the one who's not on the docket. Oh. Right, I understand. Well, Judge, we can certainly magistrate Mr. Adams. I don't see a problem representing or magistrating Mr. Florizard. The other two gentlemen, one of them's not on the docket and the other one has no paperwork, so.
Well, it's the same paperwork, it doesn't matter to me, so we'll reset Mr. Simmeline for tomorrow.
Do you want me to inform the attorneys to see if they bring Mr. Simlin? I don't know.
Why don't we see if we can get them?
Sure,
mean,
I
they
have no
all
problem
the
with
same
that.
paperwork. So there should be 4 of them. There should be Flu Rizzard, Simmeline, Kenneth Lucien, and Kendry Adams. So we need 2 more. We need Kenneth Lucien.
Judge, they're having the paperwork emailed on, Mr. Lucian.
So there's Adams, Florizard, Simmeline, and Lucian. Who is in front of me, just for, which one is Adams? Okay. So we need Simmeline and Lucian. Can we get Kenneth Lucien? Do we know where he is, Michelle? Can you call his name? Lucien. Okay, he's in North Broward, hold on. North Broward, is there a deputy there?
I would be too if I had that.
Do you have a Kenneth Lucien, Lucien? He says he's in North Broward.
We don't have him physically here, and he wasn't on the docket today.
Okay, defense, what do you want to do with him? Oh,
It was supposed to be at 1 o'clock today.
he's at North Broward. Are you representing him too?
Yeah, well, Lucy, Kenneth.
Yes. All right, I need Kenneth Lucien. I don't know why he's not on the docket, but we need him brought up here.
Okay.
All right? Do you need me to spell his last name?
Lucien?
Yes, thank you.
Okay.
Thank you. Let me know when he's up. Okay, so Lucien's not from North Broward. And Mr. Simoline, are they bringing him up, Sean?
They're bringing, Sean? Judge, from what I'm being informed right now with the deputies. Oh, that was his. Okay. Okay, so can we bring Sean someone?
Lucien is at North Broward, yeah. Yeah,
They're checking on Sean right now.
you okay?
Yeah.
Okay. You need some water.
There's no water over here.
I know. All right. All right, so why don't we have them have a seat? And we'll wait for all three of them together, okay? So who do you represent? Two of them, right?
I'd like to represent one. Kenneth Lucy.
Judge, when you have a chance of being requested by deputies, and we call a gentleman out of turn.
Sure.
He is on your second look docket.
All right, let's start with it.
His name is Presley Francois. Come on up, Mr. Francois.
Okay, and then we're gonna take the MO cases.
Okay.
Okay, Mr. Francois, how are you, sir?
Hello, ma'am, how are you?
Fine, thanks. Michelle, you gotta pull up this case. Presley Francois. This is our second look docket. Okay, he has a resisting officer without violence. He has 6 days in. What's he in for? What's his other charges?
Do you have anything else holding you right now, sir, or no? No? No, Judge. I believe it's this resisting without violence and there's a pet theft.
Okay, hold on one moment, okay?
Because he's got this, I think he's out on the award.
Okay, so, Mr. Francois, you have two resisting
The other
without
cases?
violence.
Okay.
He has a pending case in front of Judge Shear.
Yes, Judge. My understanding, the only thing, I believe his, release is just $100 bond. But now he's adamant about innocent. He's looking forward to his day in court. Judge, he is worked at a club called Atlantic Shore Club. He's been employed there for 3 years. Right now, they're holding his job, but he is from, I believe, unjustly using it. So right now, he's asking if Your Honor will consider releasing him ROR on these
Well,
misdemeanor
a shame because when did he get this? He got this 4/25.
Yes.
I ROR'd him on April 3rd because it was a motion for, the state didn't file formal charges, and the state agreed to ROR him, and now he's in trouble again? Don't talk about the facts of your case.
Yeah, well, it's kinda hard, but
Standard pretrial release. Sir, don't say anything. Just don't say anything. Standard pretrial release report within 24 hours. ROR. All right, let's go, Mr. You've been so patient. Mr. Landere, I haven't seen you in a while. How are you?
Morning, Your Honor. Good morning. Keep my head down.
Yeah.
Good afternoon. Yeah, it goes quick.
George
Even
Automobile.
Mr. Romero's coming over to look and see Mr. Landere in the courtroom.
George Odom on behalf of Mr. James Noon, and I'm standing in for Mr. McLaurin, Your Honor. He's on your second look docket. He's at Conti, I believe.
All right.
I've spoken to Mr. Noon, and I've also spoken to the city prosecutor here, and we've reached a negotiated resolution that of which Mr. Noon wants to accept.
All right, are you Mr. James Nooney?
Yes, ma'am.
Is that how you say your last name?
It's pronounced noon.
Noon, okay, I'm sorry about that.
That's okay.
All right, sir, you have a battery and criminal mischief. What are we doing with this?
That's what I understand.
Okay, so what are we doing with this?
I was.
Hold on, Mr.
Sir,
Noon.
you have an attorney here representing you, Mr. Odom, from Mr. McLaurin's office. We also have the prosecutor here, Mr. Don Landere. So let's hear what they say to resolve your case, and let's see if you then want to resolve it, okay?
And just so you're clear, you can see two people at the podium, right, Mr. Noon?
To my left?
You can see two persons at the podium in the screen, correct?
Yes.
Okay, your attorney is the darker one of the two, just so you know.
I thought I speak on the phone.
Yep, I'm the one you spoke with on the phone.
Nice to meet you, sir.
You as well, Mr. Noon. Oh,
I just want to mention that I was in a car accident and
oh,
I was in Broward General Hospital and my memory has been lost.
okay. Okay, well,
I understand I did understand what's going on.
okay, now we talked on the phone, correct?
Yes, sir.
And I advised you that the city prosecutor, and if you can state it for the record, Mr. Landere, what the offer is?
Yeah. Count one, battery. It's going to be an adjudication, court cost, 6 months reporting probation, no contact with the victim, and we're asked the court order restitution, reserve as to amount. And on count two, criminal mischief, the office and adjudication, minimum court cost, and we're asking the court also order restitution and reserve to its amount on that count. Oh, and Judge, I did say once the restitution, if there is any restitution ordered, once it is paid, if it's paid early, we would not object to early termination.
Okay, do we know which division this is going to be in, or is this in a division?
It's in, well, it will go back to Gottlieb. Currently, it's sitting in Judge Merrigan's courtroom, but I believe he may end up getting kicked out of Veterans Court. He's a veteran, which would ultimately go back to Judge Gottlieb.
Okay.
Judge, he has spent over 45 days in jail already. That's why there's no jail offer.
Okay. All right, so if there is a probation violation, he's going to have to go in front of Judge Gottlieb,
Correct.
okay?
And we're going to go there for the restitution hearing also,
Yes.
if we have one.
All right. All right, so sir, do you want to resolve your case and take that offer?
Yes, I'd like to just know what the offer is exactly before I say yes, but I'd like to resolve the case today and.
All right, so Mr. Odom, you want to tell your client what the offer is?
Yes, okay. I'll say it again to you, Mr. Noon. I'm gonna take it slow. Make sure you understand everything I say. So it's going to be count one for the misdemeanor battery adjudication. Is 6 months on one and two, or just two? Just on one. So count one on the battery will be would be an adjudication plus court costs no victim contact. Count 2, which is the criminal mischief, will be adjudication, court costs, 6 months of misdemeanor reporting probation, restitution, although we do not know the exact amount as of now, the court will order it and reserve, meaning that you will have to pay any restitution amount found to be legitimate by the court. And the city prosecutor does not object once restitution, if ordered, is fully paid to early termination of your 6 months misdemeanor probationary term. Did you understand that offer?
Yes, I understand it.
Okay. Do you want to accept that offer?
Yes, I do.
You don't want to do an adjudication time served plus court costs?
Judge, I'm looking for probation on count 1
Okay,
because
I get it.
because of the restitution issue.
What about court costs only? I thought we can only give court costs in one count if it's a single case.
Supposed to be court costs on count, as I understand, I was told it's court costs on count 1, and the minimum court cost, I believe, is $28 on count 2. That's what everyone's doing now. I don't, if there's a new memo out, I have no objection to doing court costs on count 1 only.
Hey, Madam Clerk, just so you know, there's 2 of them here. I think they stuck together. Okay.
I'm looking for probation on count 1, not on count 2. Just to be clear.
Oh, okay.
Count 2 is a mischief.
All right, so it's 28 on 2,
Probation on battery.
78 on 1. Court costs.
Court costs.
It's, yeah, I think 28 on count 2.
Yeah, I said 78 on 1, 28 on 2.
Battery court costs, I guess it's different magistrates, but battery is supposed to be, it's $654 or $54, I think,
For
65.
municipal ordinance?
He's charged, usually I charge state statute, Your Honor.
Okay, so tell me what it is.
The state statute is 784.03 for the statute, and it is 654 or 655.
654,
It's one of the 655 or 654. Go with 54 to be safe.
okay. All right, sir, is that what you want to do, resolve your cases today?
Yes, I'd like to do that.
All right, raise your right hand. Do you swear and/or,
Those things I gotta take care of.
all right, do you swear and/or affirm to tell the truth?
Yes, ma'am, I do.
All right, put your hand down. Is your name James Noon, Noone?
Yes, ma'am.
All right, it's my understanding you wish to waive your right to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, not at all.
Are you under the influence of any drugs or alcohol?
No, I'm not.
Ever been treated for a mental illness? If you have, let me ask you this question. Have you ever been treated for a mental illness that would affect your ability to understand what's going on here today?
No, ma'am.
Are you on any medications that would affect your ability to understand what's going on here today?
No, ma'am.
You're a veteran, so you understand that I'm going to put you on 6 months probation, sir. That's part of the plea agreement. And I'm going to early terminate your probation if restitution is paid early. Do you understand that?
I'll make the restitution as quick as I possibly can.
Well, you're going to have a hearing on it, so, to determine what the restitution is, because I'm going to reserve on the restitution. So, understanding what I just explained to you, do you want to plead guilty, not guilty, or no contest to battery and criminal mischief? No contest? The court is going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate you and impose court costs, which are mandatory for count 1 battery, $654, count 2 criminal mischief, adjudication, and court costs of $28. You're to have no victim contact, sir. Do you understand?
Yes, ma'am.
No victim contact means no contact in person, writing, texting, calling, nothing through social media, and no contact through third parties, okay?
I don't even know what she looks like.
All right. Well, then it shouldn't be a problem. The court is going to reserve restitution on count 1 and count 2.
Yeah, yes, Your Honor.
All right, and we're going to only put you on probation on count 1. The probation is going to be early terminated if restitution is paid in full. So you have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. Anything else? All right,
covers it all.
thank you very much.
Thank you, Judge.
All right.
We have all 4 co-defendants, Judge.
All right. Nice seeing you, Mr. Landere.
It's good to see you, Judge. You gotta come back up and visit us sometime.
Yeah, I know.
Your Honor,
Yes.
Poppy has one more.
Huh?
Poppy has one more.
Who is it?
Stephen Gordon. Gordon Stevens on the 30-day.
All right, Gordon Stephen on the 30-day. Page 2. State. Hello, Mr. Stevens, how are you?
Good afternoon, Your Honor.
All right, your attorney filed a motion to ROR you, which means to release you, because the state hasn't filed charges, but however, the state has until this hearing to let us know if they filed formal charges. So state?
Your Honor, I have no objection to their motion. We haven't filed charges yet.
All right, so, sir, you're gonna be released today. Is this your only case?
Yes, ma'am.
All right, so you'll be released on the possession of cocaine, drug paraphernalia, and violating an injunction within 500 feet. However, let me caution you, sir. You were told to stay 500 feet away. That's still in effect. If you get arrested again, it's gonna be another charge. Do you understand that?
Yes, ma'am. If I can say something, Your Honor?
Don't
I
talk about
wouldn't.
the facts of the case. Okay, you're gonna be released. That doesn't mean that they can't file formal charges against you. So if you go to browardclerk.org, you can look it up, put your name in, and see if they file charges, okay? If you move, you have to notify the clerk of court in writing and your attorney that you moved, your new address immediately, and you put your case number, all right?
Yes, ma'am.
All right, sir, good luck to you.
This case.
Okay, have a good day. You're welcome. All right, we're gonna go to back to the main jail. Let's take the 3 people, and then one of them is at North Broward. So let's line them up as follows. Let's put Mr. Adams first, right where he is. Mr. Adams, stay, move that way, yep. Then we're gonna have Mr. Fleurizard, and then Mr. Simulin. Is that your name, sir? Behind you, Mr. Ramiro?
Yes, ma'am.
Okay. All right, let me tell you, gentlemen, you are charged with petty theft, first degree, $100 bond. I'm talking Mr. Adams first, because they mixed the same charges, but they mixed them around. Count 2 is robbery by setting snatching without a firearm or weapon. We need to talk about bond. Counts 3 and 4 are grand theft between $300 and $5,000 bond. So the total bond, not including the robbery that we're gonna talk about, is $2,100. Mr. Fleurizard, you have the same thing as Mr. Adams. Did you hear what I just said to him? All right, and then we have Mr. Simulin, who they mixed it up a little. Count 1's a robbery by sudden snatching without a firearm or weapon. We need to talk about bond. Counts 2 and 3 are grand theft between $300 and $5,000, $1,000 each. And count 4 is a petty theft first degree between property between $100 to $300. Any objection to probable cause?
Morning, Your Honor. Janito Simon on behalf of Mr. Similian. I haven't had the opportunity to look at the probable cause yet.
Sure. All right, can you share it with him? All right, so we'll put Mr. Simulin on the side. Mr. Adams, the attorney for Mr. Adams, why don't you come up?
I think I'm the attorney for Mr. Adams,
Okay,
actually.
so PD. Who is the attorney for Fleurizard? Okay, so you have 2 people. All right, so let's go off of Mr. Adams and Mr. Fleurizard. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. State, what are you asking for on Mr. Adams and then Mr. Fleurizard? Let's start with Adams first on count 2 and any special conditions.
Your Honor, state would just be seeking a $1,000 bond on count 2.
$1,000 bond?
Yes, Your Honor.
Okay. And that's on Adams and Fleurizard?
Yes, Your Honor.
Okay, sir, there's gonna be no victim contact. This is Mr. Adams and Mr. Fleurizard. No victim contact, direct or indirect, with the alleged victim in this case with the initials SNJ. Direct or indirect means no contact. calling, texting, in person, writing, through third parties, anything whatsoever on social media. Do you understand? Do you both understand? I'd like to hear Mr. Adams first. Do you understand?
Yes, ma'am.
All right, and Mr. Florizer, do you understand?
Yes, ma'am.
All right, so they're asking Mr. Romero for a total of $3,100 in bond.
Judge, in speaking first, regarding Mr. Forsythe, in speaking with him, he's gonna be requesting that this court release him on pre-trial release. My understanding is this is his first arrest ever, his first contact with the criminal justice system. He is 18 years old, he's been living here his whole life. He does attend Coral Springs High School, he is a senior. He currently has a 3.8 GPA is weighted, 3.2 is unweighted. He's already taken the SAT. He's received a 1060. He plans on going to college. He's already written a letter of intent to attend New York Institute of Technology where he's going to be playing college basketball. He was ranked in the Sun Sentinel first team all-county and third team all-state. He plays high school basketball. He currently practices. His practices after school range anywhere from an hour and a half to about 3 hours. He lives in Tamarack with his mother. His mother is a caretaker from what he informed me financially. And his family doesn't have the financial resources to post bond. And from what he tells me, he's unemployed. He doesn't have any sort of money in the bank. He has any sort of assets. So he has no money to go ahead and post a monetary bond. Judge, considering these offenses are his first contact with the criminal justice system, his very, very strong ties to the community, his willingness to appear in court and account for these allegations, Judge. He doesn't want to jeopardize his future that he has before him, Judge. He will be coming to court. He will be looking forward to his day in court. We'd be asking you to consider releasing Mr. Forsythe and release on count 1, 2, 3, and 4, Judge.
I have no objection to that,
No
Your Honor.
objection? Okay, so Mr. Florizer, I also failed to mention that there are 2 more alleged victims you're to have no contact with. That's, I'll say the initials with the 3 different persons, SNJ, RH, and AZ. That's for both of you. Do you both understand?
Yes, ma'am.
Okay, I got an affirmative from Mr. Adams and Mr. Florizer as to no victim contact for the 3 alleged victims in this case. All right, so Mr. Florizer, I am going to ROR you and put you on standard pretrial release. Hold on, we're not done. You're to have no victim contact. You're to possess no firearms, ammunitions, or weapons. If you do have any, you're to surrender them to your local police department. Do you understand, sir?
Yes, ma'am.
All right, Mr. Florizer, let me check your address. 5603 Northwest 48th Ave, Tamarack.
Wait, 48th Way.
48th Way, I'm sorry, Tamarack, Florida. That's your address?
Yes, ma'am.
All right, if your address changes, it's your responsibility to notify the clerk of court in writing along with your case number and your attorney. You should be getting a court date in the next 7 to 14 days. If you don't, go to browardclerk.org and look it up and call the public defender's office, okay?
Will they mail that to you?
Yes, they're gonna mail it.
All right, and you're here for?
Adams.
Adams, okay. All right, Mr. Florizer, good luck to you. Mr. Adams, you have family here. Step forward and tell me your name and your relationship.
I'm Elizabeth Graham Hall. I'm his aunt.
Hi.
How you doing?
I'm Yolanda Adams, his mom.
Okay.
Judge, I think Mr. Adams is in a very similar position to Mr. Florizard. He's never had any contact with the criminal justice system. He's also a senior at Coral Springs High School. He lives with his mom. They've been living in the same location for, I believe, 7 years. And he has 2 elder siblings who are already in college. He intends to follow them down that path into higher education. I don't know if the state has an objection to pretrial release at this time.
No, Your Honor.
All right, so court's going to do ROR, counts 1, 2, 3, and 4, unless mom has an objection. I'm going to put them on standard pretrial release. So this is what I'm going to do. No victim contact, sir. Listen to me. With SNJ, RH, and AZ, their full names are in the probable cause, the police reports, okay? No possession of any firearms, ammunition, or weapons. If you do, you're to surrender them immediately upon your release. And you're going to be put on standard pretrial release You have to report within 24 hours. Mr. Romero, I'll explain to you what that entails. Good luck to you, sir, okay?
Thank you very much, Judge.
All right, good luck to you. All right, so. Thank you. Who are the other two I need there? Oh, wait. You know what? I need the paperwork on that. Do we have another one? Madam Clerk, can I get that back for one moment? The one I just gave you, I need their police report, unless you have one here. No, I know, we gotta make, Floor Wizard is in there. All right. You're Mr. Simoline? Okay, did you have an opportunity to read the paperwork, sir?
I did, Judge. No objection as to probable cause.
All right, so the court does find probable cause. Is that how you say your name, sir, Mr. Simoline? Gotta press the button there.
Yes, ma'am.
All right, I didn't know if I was saying it right. All right, so state, what are you asking for with Mr. Simoline? Same type of case?
Your Honor, I'm not going to have any objection to pretrial release for the remaining two defendants.
No objection?
No, Your Honor.
Okay, ROR, standard pretrial release.
My best argument when I don't have to say anything at all, Judge.
You know what, Madam Clerk, I do need the initials of the victims. Can you read them off to me, or you can hand me back the paperwork, whichever easier. It's number 1, it says no V contact, no victim contact. SNJ. Uh-huh.
No, I have one more.
Okay. All right, sir, did you hear me tell the other gentleman, no victim contact, direct or indirect, with the alleged victims? The initials are SNJ, RH, and AZ. Do you understand? All right, you're not to possess any firearms, ammunition, or weapons. And if you do have any, you just surrender them immediately upon your release to your local police department. Do you understand? All right, standard pretrial release, sir. Good luck to you. All right, I need the police report to be attached to this one. No, the police report. That's no, the police. Oh, this. Yeah, this whole thing. Yeah. This whole thing.
Judge, can we have a chance of being asked by something to call another gentleman out of
All right, you gotta give me 1 minute. I gotta get this paperwork right. Can we get a booking report on Mr. Simoline and I guess it's gonna be Adams? So we can attach it to the clerk's paperwork? Okay, yes. All right, and then this is their booking sheet. Just put that under here, the original.
Okay.
Give me copies of this, I need 2 of them. Okay? All right, so, Mr. Simoline, you're gonna give me the booking sheet.
It's printing out here.
Perfect, thank you. And then we have Mr. Adams. Who is in front of you? Who is this?
This is Mr. Sebastian Esteban. He's on the second one.
Your Honor, North Brown, you have Mr. Lucien.
Yes, they have the 4th co-defendant.
Just give me 1 moment. Too many papers here. Okay, Mr. Romero, who do you want me to call out of turn? I was just getting it.
Mr. Sebastian Esteban, he is on the second one document.
Okay, Mr. Esteban, you have, he's on page 3.
It's like only 2 days old. Huh? It's only 2 days old.
Trespassing occupied structure. Tell me what's going on, somebody.
Judge, it's a trespass, and I believe there's also disorderly conduct attached, but disorderly conduct is no bond is necessary, so it's a $100 bond. His date of arrest was on the 25th,
Judge, my understanding is, right now, no, I don't think no one's supposed to respond, so I believe that's why he's still being held. Still hopeful that he's been talking to his girlfriend, she's trying to gather funds. So he's hopeful, hopefully by the end of this week, maybe she'll come up with $100. But I'd ask you, Judge, if that's a holdup, if you would consider releasing him on.
Does he want to resolve his case or no?
Oh, that's, let me ask.
State, you have any objection?
No, Your Honor.
Adjudication, time served. Is it disorderly conduct count 2? It doesn't say in my paperwork.
Yes, Your Honor.
Do you have the address of where he can't return to?
I have the address.
Okay, adjudication, time served. Sir, sir, you don't have anything else pending, do you?
Yes, I do, Your Honor.
What do you have pending?
I have a child neglect, but I'm guessing it's you, the judge, also?
No, I'm not the judge. I only do the arrest when you first get arrested.
I'm sorry.
So let's do this. ROR, forget resolving it. He probably has a felony. ROR on the trespass and the disorderly conduct. He's ROR'd already.
Thank you, Judge.
Thank you. Good luck to you, sir.
Judge, we're done here. Thank you, tomorrow.
Okay, thank you.
He would still be getting out, though.
Okay, so. That's all right. Okay, so this is the original for Mr. Adams. Where is he? Okay, where's the top sheet for Mr. Adams? Where's the original? Okay. Here is Mr. Adams. Here's Mr. Adams' sheet. And here is the police report. All right, so Madam Clerk, this is for Mr. Adams. I don't know why we have this here, Michelle. This is another one. I guess you made a copy of it. So let's go to Mr. Simmelin. Do we have the booking report for him? Do we have the booking sheet for Mr. Simmelin? Did we get that?
I can get you that.
All right, so Michelle, this here, we're gonna put the booking report in for Mr. Simmelin right here. It's gotta go right here, okay?
She's here.
That goes for that. All right, so North Broward, we have, what about Adams? I have the booking sheet. We have the top sheet for Adams. Madam Clerk, I don't think we ever had a top sheet for Mr. Adams. Oh, where is that?
That's an extra copy. This is the original.
Okay, I want to put all 4 of them together and just double check them, because I want to make sure that they go right. I have Mr. Adams. Give me a second, sir. 1 moment, sir. So we have Adams is here. The next one, do you have Simmelin? Let me see. Make sure we have the booking sheet for him. Thank you so much. All right, so here's the booking sheet for him. All right, and then the next person is Flu Rizzard. So this is Simmelin, Adams, where's Flu Rizzard?
You need a booking sheet as well?
I don't know, I'm looking for, where's the paperwork? Just want to make sure. Yeah, no, I have the booking sheet. So the only one left is Kenneth Lucian. Do we have the paperwork on him?
Who's the one I gave to you that I came right?
Okay, we didn't do him yet, so Kenneth Lucian. All right, so you have these 3, 1, 2, 3. There you go. Thank you very much. Okay, Kenneth Lucian. Is that your name?
Yeah.
All right, and your name, sir?
Patrick Gene Gills on behalf of the defendant.
Okay, thank you, Mr. Gills.
Yes, and his mother's also
you.
here
Okay.
as well.
All right, ma'am. Can you
Yes.
state your first and last name?
Elda Lucien.
Okay.
Elda, ELDA, Lucien, LUCIEN.
All right, thank you, ma'am. All right, Mr. Lucien. You're charged with count 1, robbery by sudden snatching without a firearm or weapon. We need to talk about bond. Count 2 is grand theft between $300 and $5,000. Count 3 is petty theft, first degree, between $100 and $300. Bond's $1,000. And count 4, grand theft, is also a $1,000 bond between $300 and $5,000. So, any objection to probable cause? No?
No objection.
All right, the court finds probable cause. State.
Standard pretrial is fine, Your Honor.
All right, so you're making a request, sir?
Yes, we're requesting an ROR.
Okay. ROR, standard pretrial release. There's going to be no victim contact. And I think the clerk is going to kill me when I ask her the initials again. SMJ. SNJ. Okay. All right, thank you so much. Thanks, Michelle. All right, so there's no victim contact, sir, direct or indirect, with the alleged victims in this case. You're not to possess any firearms, ammunition, or weapons. And if you do have any, you're to surrender them to your police department immediately upon your release. You're also going to be put on standard pretrial. You have to report within 24 hours of being released. So he's not going to be able to go there today, but he can go there tomorrow because he should be released. Okay, but if he doesn't go tomorrow, he'll have a warrant issued for his arrest. So no victim contact, direct or indirect, with SNJ, RH, and AZ. That means no contact in person, calling, texting, writing, or contact through third parties. You violate that provision, sir. You're going to get arrested and go back to jail. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
All right, is his address 9000 now Northwest 40th Street, Coral Springs? Okay, thank you very much, ma'am. Good luck to you, all right?
Judge Paul Ryan would like you to call Altron Jason. He's on our second look docket.
Paul Ryan?
Yes, ma'am.
What's the name?
Altron Jason. It's a 30-day motion. I don't believe an information has been filed.
Okay, can you pull that one up, Michelle? Okay, Madam Pretrial, here you go. This is for all 4 gentlemen. Do you need this, or any of them? The police report? Okay. All right. Your name, sir? Hold up. What is your name, sir? I'm sorry, Wayne. Okay. Altron Jason? Okay, good afternoon, sir. All right, we're here for a motion for ROR. Your attorney filed a motion saying the state did not file charges. Did you file charges, state?
No, Your Honor, the state hasn't filed charges, so at this time, state has no objection to the defense's motion.
All right, so the court will grant the motion. So, sir, do you have any other pending cases?
Yes.
Okay, what do you have?
Violation.
A violation of probation? All right, so on these charges, the possession of cocaine and curb serving intoxicating liquors, you're going to be ROR'd and released on your own recognizance. I don't know when you're going to court on the other case. Mr. Reedy would be able to tell us better, but at least on these charges, it doesn't mean that the state's not going to file something in the future, but for purposes of these 2 charges, sir, you're going to be released. Good luck to you, okay? Did you want to say something, Mr. Reedy?
Your Honor,
Hold on, give us 1 moment. Is there anything further you'd like to say? All right, who's ever talking, just give us 1 moment. Just 1 moment. Sir, wait 1 moment, okay? All right, I'm at North Broward.
Your Honor, this is Tammy Jackson for a second look. She's our last one.
All right, just let us finish with 1 person and I'll pull her up now.
I don't see a court date for Mr. Jason at this time, Judge.
All right, so Mr. Jason?
Okay. All right, good luck, ma'am.
All right, thank you. Good luck to you, okay? All right, so let's go to North Broward. Thank you, Deputy. North Broward, we have. Okay, she has a municipal ordinance for where? Can someone tell me what's going on with this case?
What's the name, Your Honor, again?
Tammy Jackson, it's a municipal ordinance. I have no paperwork.
It says trespassing, right?
Yeah.
Yeah, it's the city of Fort Lauderdale.
Huh, where is Mr. Odom when you need
Wait,
him?
it's, which she has two cases then, right?
Yeah, municipal ordinance and
And a state charge,
Is there
yeah.
anybody that can pull one of these up?
Yeah.
Here's the case number for you.
Call
One of them.
Mr. Odom and Mr. Laundrie and see if they're in the courthouse.
I'll represent her, Judge. She also has a misdemeanor trespass, so.
Does?
There's two cases on it.
They were from the same incident. One of the charges was filed as a state charge and one was filed as an MO.
Okay, tell me what the allegations are briefly.
Let me pull that up.
Which one are you
I
doing?
found it. They're both the same PC, I think.
Okay.
Oh, I don't even have it in here.
And held on one or two cases?
I think it's two, Judge.
I don't think there's a bond on the municipal ordinance case. I think it's just a bond on the trespass.
So why are we here? All right, I'm gonna ROR her. Ms. Confinement, do you know why Tammy Jackson on the MO case? Because they set it for a second look. Is she ROR'd on that?
Well, she was booked no charge, but she's being held on $25 for the misdemeanor case.
Right.
But for the MO case, she was booked no charge.
Okay, so the other one, do we have another one on here?
No,
Yes, page
it's-
2, page
count.
3, I see.
It's one case, the two charges. You know how they,
It's two different cases.
I see it.
yeah.
Okay. So the trespassing, she going to learn a rent? That's the only reason I could think so. Why is there a $25 bond? She's been in 6 days?
She's been a medical reset, Your Honor.
All right, court's gonna ROR her on that. All right, ma'am, you're gonna get out of jail, I'm gonna ROR you, however, you have to come back, you have 2 cases pending. You understand?
No, did we do all of them?
Yes, ma'am.
All right. What's your address? Do you have an address? Somewhere we can send you notice?
It's, I think, 2326 Green Street.
Green?
GREENE, apartment 2.
And where's that?
City is that in, Miss Jackson?
Where?
Liberia, Florida.
Liberia? Huh? Oh, it is? So should I say Hollywood, Florida, or Liberia?
Both.
All right, do you know the zip code?
33020. 3320.
All right, Madam Clerk. You want me to write that down somewhere and we can change her address? Let me write it down. So it's 2326 Green Street. Is that where you're gonna stay? Where are you gonna go when you get out of jail? Do you have a place?
Across the street, for a restaurant, maybe, for City Plus, and head back to Liberia, if not Miami.
Okay, but how are you gonna get back to court?
I have, a mom who now is able to transport me to any, necessary appointment that I need.
Do you wanna live with her? Can you live with her?
Yes, ma'am, if she can live with me.
Mr. Reedy, what would you like to do? Just ROR and let her loose, or would you like to try to call her family? What would you like to do?
You have a number we can call, Ms. Jackson?
Unfortunately, I don't.
Do you have a phone?
She does.
Do you know her phone number?
Unfortunately, I don't.
So how are you gonna get a hold of her?
I'm gonna get, I have $6 in my, belongings, I think.
If you ask them, when you're released, if you ask them for a bus pass, they'll give you one. Okay? When you get out, go see Mr., what is it, Monahan? Lanahan.
She's gonna be released from North Broward, Judge.
Oh, well, they'll still give her a bus pass there.
Yeah, I think they can help her out.
Ask them for a bus pass when you get out. Tell them you need a bus pass, okay? All right? You understand? I don't know what time you're getting out.
Today?
Probably today, later on.
Tonight?
Tonight?
Yes, sir. I heard you and I heard you, Miss Melissa. So ask North Broward Bureau for a bus pass.
Okay, yes. Okay?
I appreciate that.
Why don't you ask the deputy right now as soon as you go? Okay? You can talk to the deputy standing right there.
Yes, sir.
All right, good luck, Miss Jackson. Come back to court when you're supposed to.
Thank you.
Okay.
Sebastian Esteban, please. Where is he?
We took care of him, Judge.
Did we? Okay, I think we're done. Oh,
We have-
Pierre Morose.
That's a medical reset.
Okay, medical reset,
And I think there's a Dwayne Smith.
and that's it?
Wayne Smith is filed.
All right, where is he?
Okay, where's Mr. Dwayne Smith? Shall we have the same docket here? This is yours, my dear. No wonder why I couldn't see that I was doing it. Yeah, that's why. This is yours. Okay, hold on. I just want to keep mine, you keep yours.
He's currently at the hospital.
Huh?
Mr. Dwayne Smith, currently at the hospital. He's unknown.
Okay, then I think we're done.
Okay, so Dwayne Smith, I'm sorry, did you file? I just want to put it from my notes.
You did.
Okay, so Madam Clerk, Dwayne Smith is going to be a denial. Charges have been filed. All right, thank you very much, everybody.
Thank you.
Thank you.
Thank you, Sarah.
Thank you. I'm not gonna see you no more. I know. Sarah, I'm gonna hunt you and find you. If your judge is out, I'm gonna make you come over here.
Yeah.
That's fine, I don't mind doing it at all.